Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today. All right, our next case this morning is People of the State of Michigan versus.
Right out the gate, the judge thinks she's high in court. Pro tip: if the person deciding your freedom suspects you're impaired, things are not about to go your way. What do you think? Should appearing under the influence be an automatic bond revocation?
Jennifer Lee Williams. This is case number 25-14094FH. Appearances from counsel.
Joanne Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear the court this morning, ma'am?
Yes, sir.
Thank you. Ms. Williams, we are here today for an arraignment on a bench warrant. This court back on August 1st signed a bench warrant for your arrest. It was based upon an order that you had failed to enroll in drug testing as a term or condition of your probation. I'm sorry, of your bond or your pretrial release. And then additionally, we had a show cause for your failure to enroll in that program. And it looks like you failed to appear on that date, which was August 1st. Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which a defendant could be sentenced up to 93 days and or $7,500.
Here's a legal nugget. Missing court or skipping drug tests could mean jail time under contempt. But instead, the judge is framing this as a bond issue. Translation: she dodged a bullet here, at least for now.
Fines and costs. The court recognizes before it, also here in the back, Ms. Alex Matsky from the Western Missaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing and have the prosecutor prove the allegations, which could even be done right now if we so chose. At that, you'd hear some witness testimony. You could cross-examine that witness. You could also present witnesses' evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions, your bond conditions could be modified, continued, or bond could be revoked and you could be remanded into custody. Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how does your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. Well, we have a couple options there. Right now, we're at 9:50 a.m. We could proceed today and take testimony, or
I don't have my file. I didn't know she was going to be arraigned up here today.
Yeah.
I do have the new allegations.
all right.
But I was just
I
brought the
don't think
warrant.
it'll be terribly necessary to resolve this today, Your Honor, unless the court deems it so.
No, it's okay. I don't think the testimony is very complex. It might take all of 30.
And there it is, the meth bomb drops. Notice how quickly bond hearings snowball. What starts as a missed test suddenly turns into drug paraphernalia, new charges, and a deeper hole.
Seconds, but the court will set it for a hearing.
I don't even have the sheet in front of me. I do have the new allegations. I just signed it.
That's okay. So is there another allegation that she test positive?
She had a pipe.
Oh, she had allegedly had a meth pipe. So that will also be dealt with at the hearing. Plus, I'm going to note that I'm concerned.
Right, okay.
I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today via Zoom.
A similar concern was raised by jail staff this morning, so I'd feel more comfortable not proceeding today.
All right, thank you very much. Now, I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore it right now because she has counsel. Her counsel has spoken for her, and we will set it for a hearing. In the meantime, the court is going to deny the defendant bond and remand her into custody until the hearing. Thank you very much. We are adjourned.
Thank you.
All right.
I'm sorry, person at the jail, what is your name?
Jennifer,
Williams.
yes,
This is case number 253631 FY, the people of the state of Michigan versus Jennifer Lee Williams. We are here for an arraignment. Ms. Williams, did you have the opportunity to meet with somebody from the defender's office today?
yes, sir,
I have a complaint that alleges that on or about August 8th, 2025, in the city of Cadillac of Wexford County, in count number 1, it is alleged that you did commit the offense of possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it is alleged that you did commit the offense of police officer assaulting, resisting, or obstructing, in particular Sergeant Zach Hicks of the Cadillac City Police Department. That is a 2-year felony punishable by up to 2 years in prison and or $2,000, and consecutive sentencing may be imposed if it happened in place of confinement. In count number 3, it is alleged
That habitual offender tag, it's like a sentencing power-up for prosecutors. One prior felony, and suddenly the max penalties jump by 50%. Do you think that's fair? Or is it stacking the deck against repeat defendants?
that you are a disorderly person who is found jostling or roughly crowding people in a public place. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In count number 1 and count number 2, the prosecution has also elected to charge you as a habitual second offender. That means that you have at least one prior felony or attempted felony in your past. That makes the 10-year felony and the 2-year felony punishable by 1.5 times that amount. Do you understand those charges and potential penalties?
yes,
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, and historically, I show a jostling in 2019, domestic violence in 20, in 24, a larceny less than 200, in 24, an attempted resist and obstruct. There was a 4A case back in 17. In 06, there was an MIP of alcohol. 22, an operating while visibly impaired. And 25, a trespass. It's my understanding that she has a bond violation out of the circuit court for I think it was a drug charge and possession of contraband, if I remember correctly. My probable cause affidavit that I read today indicates that she was maybe in absconder status in the circuit court. And I know there was a bond arraignment or bench warrant violation arraignment today in which was set for a contested hearing, if I remember correctly. Probable cause affidavit also indicated that looks like there was an attempt to apprehend her by the bounty hunters, so to speak, looking for her. Any comment regarding bond defender's office?
I apologize. I wanted to make the court aware that the circuit court, I was informed by Mr. Tubb, that circuit court did not accept any plea from her today because she appeared to be under the influence of something to them. I spoke with her about an hour ago, and that didn't strike me to be the case. So I just wanted to make that statement.
I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that, to me, it looked like she may have been nodding off at times, but I'm not sure about that. So I can understand where the court was coming from.
This part is brutal. She thought she was finally seeing her child after 3 years, but it was a setup for her arrest. Question for you. Smart police tactic or crossing a moral line?
With that.
Okay.
But
I will just say, I would be comfortable with the state of mind that she was in at least an hour ago, and assuming it's remained the same, with proceeding as usual. I would like to say that the incident, at least where she was picked up here, I don't know, I feel as if mentioning it because I found it sort of uniquely like an awful way to get arrested, was her baby's father more or less tricked her into thinking that she was going to see the child for the first time in 3 years, and then she got arrested. So I thought that kind of sucked. Not that that impacts bond in any way.
is that from when they were trying to apprehend her for her bond violation?
I believe so.
The bondsmen were trying to apprehend her?
Yes. That being said, she does have a support network that's growing here in the city. She has a partner who she would like to stay with. And then she also has I wouldn't say a job lined up, but work lined up at a house that she can stay in. So that would also take care of housing. She wasn't able to give me the address for that, but it did sound credible to me. So thank you.
I should have also mentioned that the praxis scores her at a risk level 8, which is a high risk. Is there anything about that you wanted to address? I know you already addressed the housing issue and the lead on work.
No, Your Honor.
Ms. Lawrence?
Thank you, Your Honor. I don't think I need to go into too much detail. As the court stated, they read the affidavit on this case. I think it's pretty clear the defendant cannot be successful on bond since she is on bond in circuit court for another possession of meth. And she picked up this new possession of meth while on bond, and also her failure to appear in circuit court as well. Given that, and also the fact that this did happen in a public place, a very busy place at the G&D party store in the parking lot, I do think there are some concerns for public safety in this case. I would ask for random drug testing as well as a $10,000 bond. Thank you.
What was her bond in circuit? Do you remember?
I believe I was told she had a remand.
No.
And boom, bond doubled to $50,000 plus GPS tether. That's the court saying, we gave you a chance, you blew it. Now you're basically on lockdown even if you get out. Think that's too harsh, or exactly what's needed to keep her in line.
But before she absconded. In my mind, I thought I had changed her previous bond to $25,000. All right, the court finds that Ms. Williams presents as a flight risk in that she was absconding from circuit court bond, and by the praxis, it looks like for over a month, and that she had failed to enroll. I assume that's in testing, at least based on the findings in the probable cause affidavit that I had to review in order to find probable cause for the charges today. It does appear that she was trying to be apprehended by the bondsman's bounty hunters, and it was not going so well for Ms. Williams. So I do find that she is a flight risk. I also find that she's a threat. I am going to order a $50,000 cash or surety bond since the $25,000 didn't keep her coming back to court or following the bond conditions. Ms. Williams, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. On the situation that you are released from jail, I'm going to order that you be placed on a GPS tether for location purposes only. Ms. Ejomera, anything else?
No, Your Honor.
All right, we're adjourned. Thank you, jail.
Thank you, Your Honor. Have a nice day.
You too.
are back on the record now for the 28th Circuit Court here in Wexford. And we're taking up next the case of People of the State of Michigan versus Jennifer Lee Williams. Appearances?
Nate Carnes on behalf of the people.
Robert Hartzell from Miss Williams, who joins me to my left here.
Thank you. You may be seated. Also here before the court today is Miss Alice Matsky. She's an agent with the Wexford Misaki Community Corrections Program here in the building. We are here today for a contested bond violation hearing. Are we running that hearing still, Mr. Hartel?
No, Your Honor. After conferring with people exactly what the allegations are, I've conferred with my client, and she would do a guilty plea to those.
All right, thank you very much. All right, Ms. Williams, we're here today for a bond violation hearing. So the allegation here is that on August 1st, you failed to appear as ordered for a show cause hearing, and that was itself ordered to address an allegation that you failed to enroll in drug testing. Is it true that you failed to do so, both?
Yes.
Okay. All right, the court takes a look here, takes judicial notice of the terms and conditions of your bond that were previously set while this case was before the 84th District Court, and that was set by Judge Wiggins on or about the 25th of June. All right. Okay, so therefore you're found to be in violation of your bond. So what should we do next with her, Mr. Carnes? Before I do that, let's ask Ms. Mansky. Have you had any contact with Ms. Williams on this file?
No.
All right, thank you. Mr. Carnes?
Thank you, Your Honor. The people are concerned here. This is Ms. Williams' first controlled substance file. It is allegations of possessing meth, which obviously is concerning. And then she was held in jail for probably 10 days. I'm having to do math, so bear with me. Approximately 10 days. Bonded out and then just didn't show up for testing, didn't show up for court. It's very concerning. I think a remand is appropriate given those allegations. She had her shot at bond and just she can be trusted. I think after a cleaning out period, we can see where the case goes from there. Thank you.
Well, listen, I'm going to ask you a couple questions here. Looking at the felony information, are both counts 1 and 2 both while in the jail?
Yes, Your Honor.
All right.
Yeah, same.
Same day. I just wanted to make sure that she didn't get arrested for one and then taken into the jail and then she still had it on her. That's okay.
You know what, Your Honor, I'm going to have to look back to the police report to answer that question.
Have you done do you have any more information on her prior criminal history? I see that she's got this one prior felony for assault resist.
I think there might be 2 misdemeanors. It's not an extensive criminal history.
So she's going to score if convicted, not saying that you are, but just helping understand the likelihood of confinement. Sounds like she scored an intermediate sanction cell with probably 0 to 11, at most 0 to 17. That sound about right, Mr. Hartel?
It does, sir.
Thank you. While Mr. Carnes is looking up that answer, Mr. Hartel?
Yes, Your Honor. I have conferred with Miss Williams about the situation.
Okay.
Up, down, well, you can, that doesn't matter. Go ahead, Mr.
All right. And she would, after rehearsing with me a bit to make sure that she wouldn't be saying anything that I'd advise against, and stated that she would like to make a statement in a moment, and that would be fine with me to take to court.
Sure.
What I would say is she does own up to what happened on bond. She does realize that she didn't do a few things that she should have done, and those are very important things. She does believe there's been some changes in her circumstances. She seems authentic when she speaks with me.
Does she have an address?
What is?
It's West Falmouth Road. I can't remember the numbers.
West what?
Do you know? It's Falmouth Road. Jake Wester. My boyfriend and I are staying with him. Wester. Yeah, Falmouth Road. In Falmouth. I think it's more in McBain.
Is there a difference?
Falmouth Road. Well, you know, they're
Okay, I got it. I know where all those roads
but
are.
I do.
And I know Mr. Wester. So.
I do know that you know, it's a little bit closer. It's a more stable environment. Even the ladies from CMH said that I looked a lot better. I did know by the point of the date that I got picked up, I did plan on turning myself in. I was just trying to get some things signed up and get my stuff moved over there. And I also, I had a chance to see my son, which I haven't seen my kids in almost 3 years. My daughter's been on and out of different detention centers and somewhere in Michigan, kind of just floating around. And my son's dad, the last time I saw him, he was getting him pizza and never brought him back to me. I had the chance to see my son, and I really wanted to see him, and that's how they lied to me. And I was never gonna run. It's not like I would have anywhere to go to, because I mean, plus I really want to see my kids, and I want to get sober, and I want to stay sober. I just haven't had a good living environment to do so. I had the last minute chance of being able to, I thought, see my son, and I wanted to see him before I turned myself in. And
All right, I
and
got
it
it.
wasn't.
Do you
the
have,
case.
do you have transportation to and from?
Yes, I do now.
What do you have?
Well, I don't drive. I personally don't drive, but I have 2 guys that I live with that they can get me to where I need to go. Plus Jake's dad and mom, they live just down the road, so they can also help. I swear
I got it, tell me.
okay.
It's okay, just a second. I gotta hear something from Mr. Carnes. What's the answer to my question?
Sure. As far as I can tell from this report, she was facing other charges, arrested, and when she was transported to the jail, there was a package weighing 1.2 grams. Weight package together. And that was some other person.
So she was arrested,
Unrelated.
unrelated charges, and when they apprehended her, they found meth on her as they were in processing her.
Yes.
Now, I'm told there are new charges in district court.
Yes.
What are those for?
Possession of methamphetamine. I believe there's an R&O as well, but I don't know. That had a lot of justification.
Is that in regard to her being apprehended on this?
Yes, Your Honor.
Okay. All right, got it. Anything else, Mr. Hartel?
The only thing I'd add would be, if I recall correctly, and upon conferring with her, I do believe it's accurate, their bond on that new case is $5,000, I believe so.
I got $50,000 cash surety.
That's probably where that came from, I think.
All right, thank you.
I just asked the court to factor that in. I do believe that she's going to attempt to make that bond, because she did mention that she has resources that she does have to try to help her with that. But obviously, if we remand her here, that would be a moot point.
Copy, thank you. All right, well, the court takes into consideration Michigan Court Rule 6.106. While I don't make a finding of guilt, the court is allowed to consider under that court rule the likelihood of the conviction, and if she was being searched while going into a jail and being apprehended on a warrant, there's no motion to suppress, and therefore the likelihood of conviction is quite high, at the very least, if not on both charges, at least on the one for possession. Now, if she got arrested again on this bench warrant, and during that search, they did the same thing and found her to be in possession, the likelihood of conviction there is relatively high. The court also recognizes that it gave her the opportunity for testing. She didn't do the testing. I'm supposed to be able to consider those other alternatives, such as testing and monitoring, but I can't do it unless she's there. Court therefore revokes bond, remands to the custody of the Wexford County Jail. All right, let's see if we can get these cases moving, and we'll get it on the court's docket. Thank you very much. We are adjourned.